a Scottish independence referendum. With the UK divided by Brexit and a majority in Scotland's Parliament supporting a future referendum, will there be a fresh vote? Does Westminster need to agree? It's a tricky question, and there's lots of legal misinformation out there on how the law works. So let's get it right. Referendums, generally speaking, are devolved. This means the Scottish Parliament can pass laws to hold referendums. The Constitution and the Scotland-England Union are reserved. This means that the Scottish Parliament cannot simply dissolve the Union or change the Constitution. But can Holyrood pass a law to hold a referendum on the Constitution? The Scottish Parliament has never unilaterally organised a referendum before. All major referendums in recent years, in 1997, 2011, 2014, 2016, have either been endorsed or organised at Westminster. But that doesn't mean that they need to be. Both Strathclyde and Edinburgh have held major local referendums in recent decades, and in the past century there was over 1,000 local referendums in Scotland on alcohol policy alone. Now, in 2012, it wasn't clear what the legal basis for an independence referendum would be. The Westminster government said a Section 30 order was required to give Holyrood the necessary legal powers to hold a referendum, while the Scottish Government disagreed. In the end, this disagreement didn't matter, because a Section 30 order was granted and that put legality beyond doubt. It gave explicit, albeit temporary, legal powers for the Scottish Parliament to legislate for a referendum. Today, things are different. In 2017, Theresa May ignored Nicola Sturgeon's request for a similar order, and 2.5 years later, Boris Johnson is intransigent. So what now? Well, the Scottish Government would prefer a consensual process, like in 2014, but Nicola Sturgeon wasn't prepared to just wait indefinitely. So the Referendum Scotland Bill was introduced to the Scottish Parliament, providing a framework for future Scottish referendums. The presiding officer said this bill was within the powers of the Parliament, and it means Scottish ministers can make regulations for future referendums. For instance, a referendum on whether Scotland could be an independent country. But those regulations could then be challenged in the courts as being out with the powers of Scottish ministers, so it wouldn't be so simple. The outcome of any such legal challenge is impossible to predict. Some say that because the Constitution is reserved, so is any constitutional referendum, whereas others draw a distinction between a referendum on changing the Constitution and changing the Constitution itself. Infamously, the vote in the UK to leave the European Union did not mean that the UK simply left the European Union. Those are completely distinct legal processes, and so it would be with any referendum on independence. This is totally different to the situation in Catalonia, where the Spanish Constitution explicitly protects the indissoluble unity of the Spanish nation. In Scotland, the law is far less clear. The Scottish Government priority remains a referendum with a watertight legal position, like in 2014, but it now has a backup plan. The Referendums Bill will become law this year. The Scottish Government can then bring forward regulations to make an independence referendum happen unilaterally and challenge Westminster to take them to court.